Welcome to the Public Safety Committee. I have a few housekeeping items. 2 items have been pulled. 3 from the calendar. Mr. Gilmore, item number 5, AB 1842. Item number 9, Ms. Carter, AB 1972. And item 16, Assemblyman Solario, AB 2140. We also, I'd like to have the consent calendar. We have a quorum, so could we have a roll call? But before we do that, I'd like to welcome Melinia Nelson, our new public staff attorney and public safety committee consultant, and 2 new members, Mr. Bell, who will soon be here, and Mr. Portantino. Welcome. And now, if we have a roll call, please.
Amiano.
Here.
Hagman. Here. Bell. Gilmore. Here. Hill. Portantino. Here. Skinner. No.
Okay. And now the proposed consent calendar is as presented. So moved. Item number 6, Mr. Garrick, 1848. Item number 8, AB 1961, Mr. Gilmore. Item number 11, AB 2009, Logue. And item number 17, AB 2157, Logue. We have a motion. Can I have a second on the consent calendar? Second. Roll call, please.
Amiano.
Aye.
Amiano. Aye. Hagman. Aye. Hagman. Aye. Bell. Gilmore. Aye. Gilmore. Aye. Hill. Portantino. Aye. Portantino. Aye. Skinner.
Arambula, you signed up first, but if, with your permission, could we take Mr. Cook? It should be down and dirty. Okay. Now, what happened to my binder? He was right here. Do you have my binder? Well, bring it up, though. Okay, Mr. Cook, go ahead.
Thank you, Mr. Chairman.
Is your mic?
We all set? Good morning. 8B 1906, as proposed to be amended, would allow the County of San Bernardino to impanel an additional civil grand jury. Existing law authorizes the presiding judge in any county or a judge appointed by the presiding judge to supervise the grand jury to impanel a grand jury to serve for a period of 1 year. San Bernardino has found that a single grand jury with a 1-year term is insufficient in fulfilling the vital role assigned to them to protect the public interest through critical and scrupulous government oversight. With orientation, training, and report writing, a single grand jury in San Bernardino does not have the time required and necessary for the thorough investigations of increasingly complex governmental processes and issues.
Mr. Cook moved the bill and seconded already, so.
I do have one of my supervisors from San Bernardino. He flew all the way up here. If he could say a few words.
Yeah, welcome, and thank you for reminding me that because there's a heavy calendar with many participants, we are going to be limiting witnesses to 2 and for 2 minutes. Thank you very much for the rest of the hearing.
Okay, I have Supervisor Paul Bion with me today.
Good morning, Mr. Chairman, and as well as distinguished members of the committee here. My name is Paul Biana, and I serve on the San Bernardino County Board of Supervisors. The grand jury has really been overwhelmed, and many of the interviews with the past grand jury foremen or forewomen have basically stated they weren't able to complete their tasks that they were assigned to do. In our county, we have 24 incorporated cities, 27 redevelopment agencies, 104 special districts, 41 school districts, and they have to look at the jails as well as our airports and 30 county libraries. All of these are areas that they're supposed to focus on within a 12-month period. So as Assembly Member Cook has said, it's just in order to extend those terms and as well as to add an additional grand jury is probably the most efficient way for San Bernardino County to task its grand jury to look into government in its different areas. And so we appreciate your consideration and appreciate that there was a motion and a second already in front of you.
All right, thank you.
Good morning, Mr. Chair and members. I'm Lieutenant Barbara Ferguson from San Bernardino County Sheriff's Department, and we support this bill as well. Thank you.
Thank you. From committee members, the bill has been moved and seconded. Is there any other witnesses in support? Any in opposition? And Mr. Cook, thank you for accepting our amendment. So without objection, we'll adopt the amendment. And if we could have a roll call on the bill as amended.
Amiano.
Aye.
Amiano, aye. Hagman. Aye. Hagman, aye. Bell. Gilmore. Aye. Gilmore, aye. Hill. Portantino. Aye. Portantino, aye. Skinner. Got Billy.
All right, the bill is out. Congratulations. Thank you for traveling so far.
Thank you.
Thank you very much, Mr. Chair.
Okay, we'll have Mr. Arambula. Unless you have questions.
Good morning, Mr. Chairman and members. It's my pleasure to present AB 2011. This bill is about a fee that is collected from perpetrators of domestic violence.
Move the bill.
And the fee basically allows women and sometimes their families to access emergency services and also to do outreach to prevent these kinds of situations from occurring. There's been a fee in place since 2003. That fee was a minimum of $200, and then it was increased to a minimum of $400 in 2003. However, that was sunset last year. So as of January 1st, that fee of a minimum of $400 went down to $200. What this bill does is it restores it up to $400 so that we can continue these emergency services.
All right, fine. Do you have any witnesses in support?
Hi, my name is Catherine Pettibone. I'm with the Governor's Office of Planning and Research. We're the sponsor of the bill. As the Assembly member has adequately spoke about it, it's a serious public safety issue for all of us, and with the budget cuts the state's having right now, it seems really inappropriate to cut funding to these important programs.
All right, thank you very much. Are there any further witnesses in support? Any in opposition? Seeing none. And I have a motion and a second. And Mr. Rambula, thank you for calling this to our attention. $400 for this minimum fine doesn't seem unreasonable to me. Sorry, you got to be fast here.
I apologize. I was in the back of the room. I should have walked faster. Liberty Sanchez on behalf of the California Public Defenders Association. We're opposed to this measure based on concern that increasing the existing fines will result in less overall fines being paid. There are already substantial fines associated with domestic violence defendants being required to pay for their own supervised probation, and we're concerned that increasing fines will lead to the existing fines not being paid.
All right, thank you, Ms. Sanchez. We were not aware of any opposition. I apologize. I don't know what happened, but let's work on that. Mr. Arambula, did you want to respond? We're going to.
I would just point out that this fee had been in existence for many years, and that as a result of budget cutbacks, shelters have been really hard hit, and services have declined for this very needy population. They are very vulnerable, and this fee will allow for a continuation of the services that existed prior to January 1st. And with that, I'd urge an aye vote.
All right, thank you. And I understand that this was inadvertently sunsetted. So, okay.
Amiano.
Aye.
Amiano, aye. Hagman. Aye. Hagman, aye. Bell. Gilmore. Aye. Gilmore, aye. Hill. Portantino. Portantino, aye. Skinner. Bill's out.
The bill is out.
Thank you, Mr. Chairman. Thank you, members.
I'm going to do Mr. Hagman. AB 1663. Item number 2.
Thank you, Mr. Chairman and members. I do appreciate you taking us out of order here because we do have, as you can see, we have a whole bunch of boxes of petitions that we want to get out of here and out of the committee's way. But this morning, I'm here proud to present AB 1663. And 1663 will repeal the onerous restrictions placed on the sale of ammunition by this body in 2009 and AB 962. AB 962 requires individuals purchasing ammunition to be fingerprinted and registered at the time of sale and mandates that dealers keep these records and make them available for inspection by California Department of Justice. This particular requirement changed the simple act of purchasing ammunition to act akin to being booked after an arrest. Ammunition retailers would also have to store ammunition in such a manner that it would be inaccessible to purchase, and mail order ammunition sales would be prohibited. Many of these California small businesses don't have the physical storage nor the financial resources to comply with these requirements. And it's unclear how the requiring store employees to obtain and hand customers ammunition instead of letting customers choose their own ammunition will curb crimes committed with firearms. AB 962 unreasonable regulations will negatively affect the ability of law-abiding citizens to obtain ammunition for handguns they illegally possess. The laundry list of new requirements in the Assembly Bill 962 treats innocent Californians like criminals. The only people in this bill would affect are those already following the law. AB 1663 will ensure Californians responsible gun owners are not punished by excessive regulations in Sacramento. Really what this is a good attempt by an author to curb illegal gun activity in urban areas. And even though that's a great motto that we both would like to strive for, this particular regulation does not curb that. As we know from statistics after statistics, it is already illegal if you're a felon to buy ammunition, to buy weapons, that sort of thing. They get them off the street. They buy them on the corner from people who steal them from households. This bill, these regulations are only going to hurt the law-abiding citizens who legally get the right to shoot under their safe manners. I have two witnesses with me today. Our first witness is Mr. Bill Ortiz with Turner's Outdoorsman.
Good morning. I'd like to thank the committee for allowing me to speak this morning.
Is everyone on?
My name is Bill Ortiz, and I'm Vice President of Operations for Turner's Outdoorsman. Turner's Outdoorsman was founded in 1971. We currently have 13 stores located across Southern California's largest counties. We employ 200 employees throughout our stores, our main office, and our warehouse facilities. Like most retailers in California, we've had to work hard to survive the current economic downturn by cutting costs and restructuring our business. AB 1663 would effectively repeal AB 962 and reverse the current and future negative impacts caused by that ill-conceived bill. Storage requirements, customer registration, retention of those registration records will burden us with extra cost and negatively impact our sales. So far, AB 962 mandates have required us to physically restructure our stores in order to comply with the non-accessible storage requirements of this bill. The area behind our sales counter is far too small to accommodate the ammunition that we once displayed out on the sales floor. Additionally, customers must wait in order to be shown ammo that in the past they could freely handle and peruse on their own. In the coming year, AB 962 will add enormous payroll costs by requiring employees to fingerprint and register each ammunition purchaser. Our calculation is that we would be registering or doing 13,000 registrations a month, about 156,000 times a year, and over the course of the retention of these records, we'd have nearly 500,000 records that would have to be stored within our very small stores. During a time in which we've struggled to attain a moderate amount of efficiency with respect to the huge cost of doing business in California, the new law adds additional labor costs to our store operations. The additional construction, labor, and administrative costs of AB 962, combined with the loss of sales revenues, could potentially stall the company's recovery and threaten the jobs of many of our employees. I'd like to thank the author and the committee for allowing us to speak today about the impact that this bill would have in our business, and we request that you vote aye on this bill.
Mr. Chairman, Ed Worley with the National Rifle Association, sponsors of the bill. Thank you for your time today. Behind us, you'll see a box of 76,000 letters that we in the NRA have received supporting the repeal of AB 962. In the 19 years I've been here at the Capitol, I don't think we've ever seen that many letters and that many people who are concerned about an issue. Very quickly, I'll remind the committee of last year when we had the issues on 962. 15 sheriffs opposed the bill. State Sheriff's Association is not opposing this bill. Last year, the 15 sheriffs opposed AB 962. The fact remains that this is going to be a huge burden upon large numbers of citizens in this state. There's huge problems with 962 when it comes to interstate commerce and everything else that goes on with the bill, which we won't go through the committee here today. The fact of the matter is that this bill has really got our membership so excited that I've never seen this kind of response. And the 76,000 letters you see behind us is more coming every day. So please support the bill and please vote for the bill today. Thank you, sir.
Thank you. And are there any witnesses in opposition?
Can we still register some public support?
All right. So do you want to open it up for support positions? All right. I usually prefer to wait to the end of the testimony so that we can hear support. But go ahead, sir. And just your name and your expression of support.
Mr. Chairman, members of the committee, Tom Pedersen, California Rifle and Pistol Association, co-sponsor of the bill. We'd just like to express our support and urge an aye vote.
Thank you, sir.
Good morning, Lieutenant Barbara Ferguson, San Bernardino Sheriff's Department, in support of the bill.
Thank you.
Hi, Gerald Upholt, representing the California Association of Firearms Retailers in support of the bill. Kathy Lynch, lobbyist for other organizations, happens to be in another hearing right now. She asked me to express the support of her groups, that being National Shooting Sports Foundation, Safari Club International, Outdoor Sportsmen's Coalition of California, and the California Sportsmen's Lobby. Thank you.
Thank you, sir.
Mr. Chairman and members, Sam Paredes, representing Gun Owners of California, in strong support of this bill.
Thank you, sir.
Ladies and gentlemen of the committee, Jason Delasan of Sacramento with the Concerned Citizens, 48,000 members of CalGuns.net. I urge your support.
Thank you, sir.
Ladies and gentlemen, Wayne Williams, gun owner, historical firearms collector. I strongly feel that any impediment in the ownership and use of guns as self-defense is wrong. I urge an aye vote on this bill.
Thank you.
I'm Dan Barano from Stockton, California, and I urge you to strongly to vote for this.
Thank you.
Thank you.
My name is Wayne Warren from Lodi, and I support this bill. Thank you.
Thank you.
My name is Alexis Ormison. I'm representing myself, and I urge and support this bill.
Thank you. Next speaker, please.
My name is Eric Ormison, Olivehurst, California. As a gun owner and a citizen of this state in good standing, I strongly urge support of this bill.
Thank you, sir.
Good morning. I'm Paul Petok. I represent myself and about 1,500 other people that know me. Yeah, I got a big mouth. We all do, strongly urge you to support this bill. Thank you.
Any other support? All right, seeing none. Ma'am? No. All right, if we could now have any witnesses in opposition. I want to welcome Assemblyman De Leon.
Good morning, Mr. Chair. Thank you, Mr. Chair and members, for this opportunity.
It is a documented fact by the RAND Corporation that every day criminals stroll into stores, walk up to register, and buy and load up on pallets of bullets used to terrorize our neighborhoods. In just 2 months alone in the city of Los Angeles, the RAND Corporation found that over 10,000 bullets were sold to criminals at gun shops and sporting goods across the city. Extrapolating those exact numbers, statewide, 500,000 bullets were sold to criminals in just 1 year, statewide. That means that more than 94,000 handguns are fully loaded with bullets by criminals each year. Now in statute, AB 962 requires what over 13 cities across California are effectively and currently doing, recording ammunition purchases to provide enforcement and investigative tools for law enforcement. It takes a second to leave a thumbprint. It just takes another second to show your ID and record your information. For those who think that these additional few seconds won't deter criminals, well, it works. Let me be very clear about that. I think the city of Sacramento is a prime example. In just 1 year alone, Mr. Chair, as well as members, 1 year alone, using these records, the Sacramento Police Department found over 150 criminals and mentally ill individuals who purchased ammunition in city shops. By using their purchaser information, they saved lives. And if a statewide requirement can save your children, your child, my child, from staring down the barrel of one of these 94,000 illegally loaded handguns, then I think it's well worth it. This is what AB 962 does. Now, AB 1663 by Assemblymember Curtis Hagman attempts to repeal those provisions. Instead of attacking AB 962 by trying to repeal it, I say to the proponents of this measure, as I repeatedly have, I am willing to work together with you to address the concerns and mitigate any inconveniences, particularly for those individuals who are rural gun owners. But don't undermine the attempt to save lives by repealing AB 962 just to advance a political agenda. AB 962 isn't creating a black market. That black market has already been created a long, long time ago. Requiring that the ammunition be stored out of reach of the customers will reduce the instances of ammunition theft. AB 962 is about saving lives. It's about saving the life of that child who will face a gun loaded with an illegal bullet, which we might have prevented. Let's not take away a tool for law enforcement to stop illegal bullets being sold into the hands of criminals as well as gang members. Members of this committee, I respectfully ask for you to hold this measure. Thank you, Mr. Chair.
Good morning. My name is Juliette Leftwich, and I'm the legal director of Legal Community Against Violence. We were a co-sponsor of AB 962. The legislature enacted AB 962 last year because it found that it was a common sense law that would keep ammunition out of the hands of criminals and young people and other prohibited persons. More specifically, the legislature found that the safe storage provisions would deter theft, that the record-keeping provisions would help law enforcement identify persons who illegally possess ammunition as well as firearms, and that the face-to-face transaction requirement would help curb illegal ammunition sales that are completed through the mail. As Governor Schwarzenegger stated in his signing statement last October, Assembly Bill 962 reasonably regulates access to ammunition and improves public safety without placing undue burdens on consumers. We urge your no vote. Thank you.
My name is Nick Wilcox on behalf of the California chapters of the Brady Campaign to Prevent Gun Violence. We were also co-sponsors of AB 962. When the governor signed this legislation, he took the unusual step of issuing a signing statement, and in that signing statement, he got it right. He basically recognized that local governments have demonstrated that requiring ammunition vendors to keep records of ammunition sales improves public safety. These records have allowed law enforcement to arrest and prosecute persons who have no business possessing firearms and ammunition. 5 members of this committee voted for it in the Assembly. I urge you to vote against this bill and preserve this important step that we have taken in improving public safety. I urge your no vote on AB 1663. Thank you.
Thank you, sir. Any other expressions in opposition?
Jim Lindberg, Friends Committee on Legislation of California, also in opposition.
Thank you.
Amanda Wilcox, I'm leader of the Nevada County chapter of the Brady Campaign to Prevent Gun Violence, and we are opposed to this bill.
Any other opposition? Please approach the mic. All right, I don't see any.
Yes, thank you, Mr. Chair. And I do appreciate the context that this bill was brought up in to keep people safe. And I'm one of those that believe in those same contexts and same goals. This bill, the original bill 962, went over too far in the practicality side of trying to keep those goals together. The 1663 would be the first step in my commitment to repeal this bill and then work on a new set of regulations that would keep hands out of the criminals, and not unduly hurt our small business or our rights in the state. You just see, in 3 months, in my short tenure up here, we've never seen 76,000 individual Californians contact our office. And for those members on the committee, I know myself, we receive hundreds and hundreds of phone calls and emails almost daily lately on this issue. This is a passionate issue. I can represent the constituency that we want to have safe streets and safe neighborhoods, but there's right ways of doing it, and AB 962 is the wrong way of doing it. I'm committed to work with the author of that to make the right ways as we go forward, but I think the first step is to pass in 1663 and starting off with the rules that were in place. California already has the most restrictive gun laws in the nation. It has shown that fingerprint and registering of ammunition buyers have not worked by the federal government over the years. I won't go through all the old arguments before, but this is not the right way of doing it, and I respectfully ask for your aye vote.
Comments from committee members. Mr. Gilmore.
Thank you, Mr. Chair. I want to thank my colleague Kurt Hagman for carrying this bill. I certainly respect the opinion of Mr. De Leon. This AB 962 generated quite a discussion on the assembly floor, and this bill will too, hopefully, if it goes forward. I want to commend you. Oftentimes here in the legislature, this body enacts very restrictive regulations on businesses, and I think by the testimony from the gentleman from Turner Outdoorsman solidify that statement. We are a very heavy, burdensome regulating state, probably the most of any state in the United States, and it's hurting businesses. I support this bill, and I hope that it would move out of the committee today. Thank you.
Thank you, Mr. Gilmore. Any other committee comments? All right. I just have a couple. As you know, this bill was passed and signed by the governor. I'm under the belief that it's a little too early to consider repealing this law. Before ammunition registration was made law across California, there were studies that showed that most of the criminals prohibited from purchasing ammunition that managed to obtain bullets were buying on the internet. Sacramento, as Mr. De Leon referred to, does have a pilot program of sorts. Law enforcement did manage to track down some criminals using the ammunition registrations. It's also worth noting that a pilot demonstrated that those who lawfully used their weapons were still able to get their ammunition. I am of the opinion that AB 962 is in the best interest of the justice and prevents harm. AB 1663 would repeal that law before it has a chance to work, so I am urging a no vote. Okay?
Second. I second.
Roll call, please.
Lamiano?
No.
Lamiano, no. Hagman? Aye. Hagman, aye. Bell? Bell, no. Gilmore? Aye. Gilmore, aye. Hill? Portantino? Portantino not voting. Skinner? So on call it needs to.
Call. Thank you, Mr. Hagman. Mr. Miller, I believe we're ready for you.
Mr. Chair, if I just may add one thing, I am cognizant that those individuals who came in support of this measure, Mr. Hagman, a lot of law-abiding citizens. I just want to give my commitment showed on the record. I'm willing to work with Mr. Hagman to try to address the inconveniences for those individuals who are the rural gun owners.
Okay, leave your guns at
Thank
the
you,
door,
Mr. Chair.
though. All right. Ding.
Hi, Mr. Chairman.
I believe you have two bills up.
We do.
Yes.
We do. 2057 is, we'll do that one first, if that's okay?
Sure.
Okay.
Item number 13.
AB 2057.
Okay. 14, pardon us.
Okay.
Thank you, Mr. Chairman. Thank you, committee. AB 2057 will close a procedural loophole that has allowed jointly charged felony defendants to manipulate their time waivers to secure unwarranted dismissals and sever their trials to use an empty chair alibi. This is a very, very narrow procedural bill. It's technical, but it's important to pass to maintain a healthy judicial system. I should point out that this only applies to felony co-defendant cases. These cases are mostly gang-related, where there are multiple co-defendants. It only applies to preliminary hearings because it already applies to jury trials. It only applies when both co-defendants have waived their 10-day right to a preliminary trial, and where one defendant waives their 60-day right to a preliminary trial and the other defendant does not waive their right. The judge may only grant an extension of time beyond the 60 days to the extent that he or she finds good cause. I would urge an aye vote. With me today, I don't have Coda, I have Peter to testify. Is Corey here too? Okay.
Good morning, Mr. Chairman, Assembly members. My name is Peter Lynch from the San Mateo County DA's office on behalf of CDAA. This bill would, as described, eliminate a bit of a loophole. Under Penal Code Section 1050.1, there's a preference, a public policy preference, to have co-defendants tried together. Earlier in the process, when we have a preliminary hearing, which is a shorter hearing, but it's a probable cause hearing, you want to maintain that joinder also so that the trial can happen at the same time. Because of the court decision that came out last year, it sort of flagged a loophole whereby defendants who could not otherwise force a severance of their cases could do so by one waiving time, one not waiving time for the preliminary hearing, and this closes that. There have been some letters in opposition dealing with the issue of one defendant could essentially make another defendant who can't make bail stay in custody. And actually that is handled much earlier than 60 days. People don't have to languish 60 days in jail to get out. If somebody is innocent or simply wants to have their case dealt with speedily, they refuse to waive time, and that's the 10-day rule for preliminary hearings. And then even if a co-defendant says, well, I want to take more time to get ready, whatever, the one who refuses to waive time, as long as a judge finds good cause for the other defendant continuing the hearing, they get out of custody. They don't even have to post bail. So it's not an instance where somebody has to stay in jail because of what a co-defendant who's working at cross purposes may wish to do. Thank you.
Is there another witness in support? 2 minutes.
Hello, good morning. Gail Stewart on behalf of Bonnie Dumanis, County District Attorney of San Diego. We are in support of the bill.
Thank you.
Karen Pink on behalf of the California State Sheriff's Association in support of the bill.
Thank you. Any other witnesses in support? Please come to the microphone.
Jim Ricketts of the Independence Caucus here in support of the bill.
Thank you, sir. Any other? Please line up. All right, seeing none. We have witnesses in opposition.
Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We are a statewide association of criminal defense attorneys. We are opposed. The committee analysis really does an extensive job in explaining kind of what the tension is in current law between some of the current statutes. And our concern is that we have clients that for a variety of reasons choose not to waive the 60-day time limit. And if they choose not to waive that limit, they have a right and they should be able to get into court and have the preliminary hearing. Now, part of the proponent's argument is that it's just a preliminary hearing, not a lot happens. But there are occasions where you can actually exonerate your client during the preliminary hearing. Now, what this bill would allow is give a co-defendant who may not have the same interest as the other co-defendant. In fact, they may have adverse interest. In fact, the other co-defendant may be pointing the finger at the other co-defendant. That co-defendant would control whether or not that person gets into court, gets in front of a judge, and has a preliminary hearing. That is simply not acceptable. Now, I know they're talking about it's more efficient for prosecutors, it's easier for prosecutors, and while that might have some merit and some value, it should not trump the right to someone who is falsely accused, who wants to get in front of a judge, who wants the evidence in front of a judge, who wants to be able to cross-examine witnesses within that 60-day time period. And to give control to a co-defendant really just undermines the core values of our criminal justice system. And that's what this bill does. Granted, there is a tension in current statute, and granted, the court decision didn't go the way that the prosecutors wanted it, but that's what we have now. So this is not the way to fix it unless you simply want to take away the right for someone to get in front of a judge and to get exonerated as quickly as possible. We may want to believe that everyone who is accused of crime is guilty, but they're not. There are innocent folks, and we have to take that into consideration when we're voting on policy and the merits on policy. And this is a clear example of whether or not we're going to protect innocent individuals who want to go in front of a judge and get exonerated as quickly as possible. For those reasons, we ask you to oppose the bill.
Libby Sanchez on behalf of the California Public Defenders Association. I just want to underscore the comments made by my colleague and also point out that we just fundamentally disagree that there's a loophole in existing law. We believe 1051 provides an appropriate balance to ensure that the interests of both co-defendants are appropriately addressed in situations where there are co-defendants. For those reasons, we urge your no vote on this bill.
Mr. Chairman and members, Francisco Labac on behalf of the American Civil Liberties Union. My two colleagues have delineated the opposition. We also are in opposition. Thank you.
Any other expressions of opposition? All right, seeing none. Are there any comments from committee members? Mr. Hagman?
Just running through, I mean, I've dealt with a lot of criminal cases, and sometimes those hearings can go on quite some time when one defendant pulls things off. Doesn't the right for the defendants not to waive their 10-day to begin with, and how does that factor into it?
Yes, someone who wishes to be exonerated quickly simply does not waive the 10-day rule for their preliminary hearing. If the judge finds good cause for continuance, even though they refuse to waive the 10-day rule, they at least get out of custody, and then the co-defendant still has to justify to a judge good cause for continuing it beyond the 10 days. So not just the 60 days, but you're going to have your preliminary hearing well before the 60 days is up, simply because the judge is charged with making sure that the co-defendant who wants to take more time has to establish on a strict timeline how much time it will take them to do that.
Any other comments before close? All right, Mr. Miller.
Thank you, Mr. Chair. I think just to underscore that last point, that if they are innocent, they won't waive the 10 days. I think, as pointed out, that this current system allows defendants to point fingers at each other. That's exactly what we're trying to prevent. We're trying to prevent the separation and preventing defendants from pointing fingers at each other, falsely accusing, thereby having that empty chair that would cause the problem. And so that's why we would urge your support.
Thank you. Mr. Miller, I appreciate your intent here. I'm just not convinced that a legislative solution to this problem is appropriate. Even if a legislative solution was, I don't really care for the direction this bill is taking. Every individual has a fundamental constitutional right to a speedy trial. Constitutional law demands that preliminary hearings occur relatively close to an arrest in order to determine probable cause. Right now, I understand the Court of Appeals is split on whether the penal code violates the 60-day rule or not. If one co-defendant wants to appear at a preliminary hearing within 60 days, I think that justice demands that he or she not be denied a fundamental constitutional right, just to convenience the DA. So again, I thank you for your intent and your hard work on this, but I am going to recommend a no vote on this. So if we can have is there a motion?
Move.
Second. All right, a roll call, please.
Amiano?
No.
Amiano, no. Hagman? Hagman, aye. Bell? Bell, no. Gilmore? Gilmore, aye. Hill? Portantino? Portantino not voting. Skinner? Skinner, no. Phone call.
Okay, on call, Mr. Miller. And you have one other issue? Item 13, 2054.
AB 2054 applies to rape penalties. It's a strong public safety measure that will make all forms of rape punishable as a violent felony, a crime for which good time credits are only available up to 15%. Criminal required to serve minimum of 85% of sentence. Currently, only rape crimes committed by force are considered violent felonies. Rapists who perpetrate their crime without the use of force are only prosecuted as serious felons. Serious felons are eligible for good time credits up to 50%, 50. AB 2054 will treat all rape crimes equally and will take away the incentive for rapists to prey upon victims who are developmentally disabled, intoxicated, or otherwise unconscious. With me, I have Robbie Hightower, representing the Riverside County District Attorney's Office, the sponsor of the bill. I'd be happy to answer any questions.
Sir?
Good morning, Mr. Chairman and members of the committee. This bill will simply fix a loophole in the law that allows those who commit rape in other forms not specifically stated as those that are forceful to actually qualify for 15% credit. The legislature has already determined that those individuals who perpetrate the crime of rape, whether they be against individuals who are developmentally disabled, unconscious, or intoxicated, are already considered forms of rape by the legislature. In fact, many of the individuals who commit these particular sorts of rape are committing them with a great deal of criminal sophistication. There's oftentimes planning involved. Members of the committee, I urge you to vote yes on this bill because this will simply allow those individuals who are committing non-consensual sex with an individual who is not capable of consenting, whether it be because they're unconscious or not capable because of some mental disease or defect, to fall within the same credit statute as those currently on the books. This does not add any new time, as all of these offenses are punished the exact same way, and all are already considered strike offenses. This does not change the three strikes law in terms of adding new strikes, but simply brings in line those that are committing these crimes through criminal sophistication into the 15% credit area as those who commit this crime by force. With that, I'd be happy to answer any questions that the committee has as well.
All right, thank you. Are there any other witnesses in support? All right, seeing none, are there any witnesses in opposition? Seeing none.
Move the bill.
Okay. Any other comments? Mr. Miller and to the witness, I know your hearts are in the right place. I mean, rape by any means is horrific, and it just goes without saying that a person convicted of rape needs to be punished. There is a penal code, section 2933. Point 1, it does not list what particular offenses should only receive the 15% credit. This section cross-references the violent felony list. If it's the intent of the author to limit credits for inmates sentenced for the rape of an unconscious person or with use of a controlled substance, consistent statutory construction demands adding penal code section 261A, 3 and 4 to the list of violent felonies. I'd be happy to work with the author in regard to this dimension, but currently, while I understand the desire to enhance the penalty for certain crimes like these, the bill as written doesn't currently enhance for these certain kinds of rape, but it certainly leads to that direction. And I just think we cannot continue to pass bills which will cause our prison population to increase. Again, I think your intent is a noble one, and I applaud it, but I will be recommending a no on this measure, and I would be happy to work with you about addressing the proper penal code. So I think we can get to where you want to go.
I appreciate that, Mr. Chairman, and if I can just underscore just a couple points in my closing comments, if I may, that this doesn't add time to the sentence, and that you really could argue that these individuals that are committing rape on people that are unconscious or developmentally disabled are actually, worse people than other similar crimes. They've had to pre-plan out what they've done. There's been a lot of thought process that goes into how they've actually committed this crime and put their victim in that circumstance where they have been, and to eliminate the good time credits and make it equal to all, as in all rapes, taking away the 50% good time credits. I think we'd like to work towards that effort. So appreciate your consideration.
Got my commitment. Thank you. Okay.
Amiano?
No.
Amiano, no. Hagman? Hagman, aye. Bell? Bell, aye. Gilmore? Gilmore, aye. Hill? Portantino? Portantino, aye. Skinner? Skinner, aye. Bill's out. Oh, excuse me. Skinner not voting. Bill's out.
All right. Thank you, Mr. Miller. All right. I don't see any other assembly members here, so maybe we could, huh? No. Mr. Portantino, would you be ready to present?
Yes, I do, and I'm going to run out to BMP. I'm first up at 10, so I think I can do this at once.
Okay. Hina.
Mr. Chair and members, thank you for letting me present AB 1999, the 911 Immunity Bill. I introduced AB 1999 to make sure that all Californians feel that they can call for emergency medical attention when they need it. Over the last year, several young people have died due to the suspected alcohol poisoning who may have benefited from this law. Friends of the deceased teens have said that they were scared to call for help because they did not want to get into legal trouble. Now let me be clear, this bill does not condone underage drinking. As the father of an 18-year-old, I would never do that. What it does do is give young people a lifeline if they have made a mistake. I want to know that if my daughter or someone else's daughter or someone's friends or someone else's child were ever in need of help, their peers would be favorably inclined to seek that help. AB 1999 sends a message that if you do the right thing, by helping a friend in distress, you will not be punished. Research has backed this up. A study done at Cornell University has proven that 911 immunity policies lead to an increased number of young people calling for emergency help. They also lead to an increased number of young people who seek help for problem drinking. In the 2-year study after the school publicized their new immunity policies, 22% more teenagers called for emergency medical attention, and 61% felt less scared to do so and were more inclined. Under AB 1999, the immunity will be limited to the victim and to one or two peers if they act in good faith and make that call and stay at the scene. Recently in my own district, a young person was tragically at a party a block away from a sheriff's station, and his peers didn't know what to do and drove him around for an hour and took him home, and he died. I spoke to that victim's mother, and she said to me about 2 weeks ago, she said, I don't know what killed my son, but I do know if he was given emergency medical treatment in the last hour of his life, he'd probably be here today. This legislation has enjoyed bipartisan support in the 3 states that have done it, and it has bipartisan support in this House as well, and I respectfully ask for an aye vote.
Thank you, Mr. Portantino. I really thank you for bringing this bill forward today. I do have a couple of questions for you. I've introduced a similar bill and support this concept, but have a few questions. Why is it that you've limited your bill to only minors and alcohol when many people die from those preventable drug overdoses each day?
Well, the point is that if you're not a minor and you make a phone call, if you have possession of alcohol, you're not going to be subject to being arrested for underage drinking. It's the minor who is subject to that potential problem, so therefore this is germane just to the minors.
Okay, so your bill only provides cover for those who are themselves under 21,
Correct.
and the person suffering from potential alcohol poisoning is also under the age of 21.
Correct.
And I don't believe, though, that it's your intent that a person that is 20 years or younger who is drinking with their 21-year-old friend should not call 911.
Correct.
Yeah.
Correct.
But the police should still charge the 20-year-old with a crime if he or she calls 911.
I think that's something that we should look at, because that's a very good point, Mr. Chair. The intent is to incentivize the underage drinker to make the phone call, and certainly if their compatriot is 21 or older, it would make sense that the same Good Samaritan behavior also be afforded to the teenager who makes the phone call.
Yeah, I do believe the bill could be more expansive, but I am supportive.
Thank you.
Mr. Gilmore.
Thank you, Mr. Chair. Mr. Portino, I'm in favor of the bill, and I'm curious, do you have, should this bill move forward and become law, do you have a plan into effect to bring this to the attention of the public?
And that's a very, very important part of this. Obviously, teenagers who know about it are more inclined to make the phone call. So yes, we plan on, obviously I sit on the Higher Education Committee. We plan on working with certainly the public colleges and universities in our state to get the word out through their networks and through their ASBs, and same thing through PTAs in high school. We already enjoy the support of one PTA. Actually, this bill had its genesis, believe it or not, on Facebook by a PTA president who read about New Jersey's law and contacted me on Facebook. So I certainly want to give credit to Kathy Hernandez, who was that PTA president. So we're also going to work through the statewide PTA network. We have not received state council support yet, so I want to be clear. We have individual PTAs, so that would be the second part, is to make the teenagers aware. And frankly, as I talk to them, every single teenager said that's a great idea to do this.
Liberty Sanchez on behalf of the California Public Defenders Association, as well as Laborers Local 777 and 792, in support of this measure.
Thank you.
Mr. Chair, Chris McKaylee on behalf of the California Ambulance Association, and we join our colleagues in Texas and New Jersey that supported similar legislation. And like Mr. Gilmore, we would offer to the author, we'd also like to be a part of that public education campaign. Our board feels very strongly we should do whatever we can to incentivize a call to 911 and don't want to diminish anyone's desire or willingness to dial 911. Thank you.
Thank you. Thank you, New Jersey. Have any other witnesses in support? Or Mr. Bell?
I just want to say I strongly support this. We had a young lady that lost her life in our community recently. It was interesting that the girls that were drinking had parents that were in law enforcement, and they, because of fears and so forth, neglected to call right away, and we lost a wonderful young lady. So I strongly support this bill. I think this would help save lives, and appreciate Mr. Portantino for introducing the bill. I'd like to be added as a co-author if I could.
All right, any other comments? Any witnesses in opposition? All right, seeing none. Mr. Portantino, would you like to close?
Thank you, Mr. Chair and members. As you know, this is an issue that affects people throughout the state. And when something threatens the life of a young person, we certainly want to know that other young people do everything in their power. And I just appreciate the comments and support of my colleagues, and respectfully ask for an aye vote.
Thank you very much. Do we have roll call?
Amiano?
Aye.
Amiano, aye. Hagman? Bell? Aye. Bell, aye. Gilmore? Aye. Gilmore, aye. Hill? Aye. Hill, aye. Portantino?
Aye.
Portantino, aye. Skinner? Skinner, aye. That bill's out.
All right. Congratulations.
Thank you, Mr. Chair. I'm going to go present in B&P. I have one question on a bill that if I miss the hearing, Mr. Bell is going to ask for me. So
all right,
if you would indulge me to go present. Thank you.
Thank you very much. I wonder if the sergeants could identify some of the location, some of our...
It's just Miss Swan. And you have a bill
and Mr. Logue, right?
No,
Or is that on
Logue is on
consent?
consent.
All right. So I will present my bill now then. I guess it's just Ms. Ma. And another housekeeping item, I misspoke about my vote on Mr. Miller's 2054. It is staying off, not a no vote. All right, thank you, and I'll present my bill now. Our vice chair is not here, so Mr. Bell, would you assume the role, please?
Thank you. We'll call Mr. Amiano for item 4, AB 1811.
Thank you very much, Mr. Bell. And members, I present to you AB 1811. My bill would clarify existing law to ensure that drug paraphernalia is defined as objects designed or marketed for use in ingesting or injecting unlawful controlled substances. Already, this is the intent of the law. Medical marijuana users are lawful users under Prop 215. That is without question under California law. As such, not only can patients grow, possess, and ingest marijuana under California law, that they should be able to ingest marijuana in whatever manner works best and easiest for them. There have been reports in some areas of the state that law enforcement officers are threatening medical and medicinal users, legal dispensaries, and other who lawfully possess objects deemed paraphernalia because these items are listed as illegal items in the law. My bill would make very clear that those who are using paraphernalia in legal ways, including bona fide medicinal marijuana patients, are not committing a crime simply for owning those objects necessary to use their medicine. I thank you for your attention. I have two witnesses.
Thank you. Dale Geringer with California Normal, one of the co-sponsors of Proposition 215. Just wanted to point out to a couple of items in particular that would be recognized legal under this bill, which are not now. One has to do with testing equipment or any equipment that is used to test the purity or the safety of medicinal marijuana is technically paraphernalia under the current law. And there's a lot of interest in beginning to test marijuana and make sure that there's no problems with impurities. And Los Angeles City Council, in fact, just passed a law requiring that marijuana be tested. Yet that is paraphernalia and illegal under current law. So this would fix that. The other thing is that there have been some major advances in smoking or inhalation technology in the last few years. There are now devices known as vaporizers that completely eliminate the smoke from inhaled marijuana. They permit people to inhale marijuana with no adverse effects in the lungs. These devices are now being used in medical studies at UCSF and elsewhere, but they too are paraphernalia, but should be legal. So I would point to those two particular concrete benefits.
Good morning, Glenn Backus for Drug Policy Alliance Network, in support.
Others in support? Testimony opposed? Anybody opposed? Closing statement, Mr. Amiano?
Yes, I would appreciate an aye vote on the part of the committee. Thank you.
Questions of the committee? If not, we have a motion on this item.
Second.
So motion is second to approve the item. Call the roll, please.
Amiano?
Aye.
Amiano, aye. Hagman? Bell?
Aye.
Bell, aye. Gilmore? Gilmore, no. Hill? Hill, aye. Portantino? Skinner? Skinner, aye.
Bill's out.
Thank you. Right, Mr. Hill. Good morning.
Good morning, Mr. Amiano. Thank you, Mr. Chair. Do AB 1601 first, if that's appropriate?
Yes, item number 1.
Thank you. Mr. Chair and members, under current law, you have to hurt or kill someone while driving under the influence for your license to be revoked. This bill would give judges discretion to revoke a license if someone receives 3 or more DUIs. The judge would have to take various considerations into account when deciding to revoke a license, such as the period of time that has elapsed since the previous convictions, successful completion of an alcohol treatment program, and the risk to public safety. The bill also corrects an unusual system in state law that erases a driver's previous DUI convictions after 10 years. This is why you read stories like the individual in Sonoma County who had 12 DUIs and was able to get his license back because his convictions were spread out over several years. He was arrested in November for drunk driving and received his 13th DUI. California's arbitrary 10-year window rule also allowed 2 of my constituents to get their licenses back after receiving 8 DUIs. They both received their 9th DUI late last year. Fortunately, no one was killed by these particular drunk drivers. But if you look at the statewide and national statistics on drunk driving, the numbers are staggering. According to 2008 data from the National Highway Traffic Safety Administration, there are over 310,000 Californians with 3 or more DUI convictions. 310,000. I think that's the population of Riverside or San Bernardino, or Bakersfield, I think. In 2008, over 1,000 people were killed by drunk drivers in California. 1,000 people killed and over 28,000 were injured by drunk drivers. The National Highway Traffic Safety Administration estimates that 1/3 of the annual 1.5 million DUI arrests are repeat offenders. AB 1601 is supported by the California District Attorneys Association, the California State Sheriff's Association, of which we have Sheriff Christensen from Stanislaus County with us today, Peace Officers Research Association, California Peace Officers Association, San Bernardino Sheriff, and the Santa Rosa Press Democrat. I want to review current law for you in regards to a DUI conviction. DUIs, the first one, first second, first third DUI is a misdemeanor. The 4th DUI is a wobbler, which means that you could get a DUI every 2 years and still never get a felony. Because after that 10th year, that first one will be wiped off. If you spread the DUIs out beyond the 10-year window, you have a clean slate and you can start over. My witnesses today will tell you their personal stories about losing family members to drunk drivers. I'd like you to think about their stories because they could be one of any one of our stories. I share their story since my best friend was killed by a drunk driver several years ago. Remember that nearly 1,000 people die in California every year because of drunk drivers, and over 28,000 are injured. Kind of surprised, well, very good. So now I'd like to introduce, if I could, our witnesses who will talk a little bit about their personal story, Peggy and Susan and Sheriff Christensen. Peggy, if you would be kind enough, let me give you my...
Thank you, Assemblyman Jerry Hill, for giving us a voice today. My name is Peggy Fong, and my daughter, Kendall Louie, was killed by a drunk driver, Michael Demetres, on July 4th, 2006. Not only did he kill Kendall, but he killed Brian Haight and broke the neck of a third passenger. In the criminal court case against Demetres, the judge, in a moment of indignation, revoked his license permanently. Needless to say, we were elated by the judge's decision to invoke this additional punishment. To us, it was just and appropriate. Michael Demetres killed while driving under the influence, therefore, permanent loss of his privilege, not his right to drive, was the perfect justice. Unfortunately, we found out that the judge did not have the authority to do so under our current laws and vehicle codes. So this drunk driver who killed will continue to keep his privilege to drive when he gets out of prison. This is why I am here today to support Mr. Hill's proposed legislation for permanent license revocation after 3 or more DUI convictions. This DUI legislation is a logical step in the right direction. It addresses the most critically needed authority for permanent license revocation in our DUI laws and vehicle codes, which do not exist today for multiple DUI offenders and even for those who cause deaths. It is time to beat the repeat drunk driver at his own game. That is, to take his car or weapon of choice permanently out of his hands and make his loss of license or the loss of his privilege to drive a permanent consequence. I would also ask that Mr. Hill add to his proposed bill that if a drunk driver kills, regardless of the number of DUI convictions, there will be a permanent loss of license. As a mother of a DUI victim, I believe AB 1601 is a common sense and straightforward bill that will deter drunk driving. Drunk driving is a serious crime and must be met equally with a serious consequence of permanent loss of license. Thank you, Assemblyman Hill, for proposing AB 1601 for the safety of the people of California.
I'm Susan Haight. I also thank you, Assemblyman Jerry Hill, for inviting us here today to speak. Peggy and I, unfortunately, have firsthand knowledge of how a drunk driver can instantly change a happy and joyous family into families filled with constant despair and sadness. Because of a drunk driver's actions, I've come to define my life before and after, before the crash and after the crash. Before the crash, my only child, Brian Haight, 19, was a loving son who had fulfilled a dream he'd had since the 6th grade to attend UC Berkeley. He was home for the summer and was really looking forward to going back as a sophomore. His good friend Kendall was 18, a dancer, an economics major who finished her freshman year at UC San Diego. They both were honors students. Then on July 4th, 2006, a drunk driver violently and recklessly killed them both. As a result of this horrific drunk driving crash, I unfortunately had to learn about many disturbing statistics about drunk driving. One astonishing one to me is that data estimates that a person drives actually 300 times before their first arrest. And in America, we have 13,000 people a year killed by drunk drivers. That's almost every 40 minutes someone's killed. Authorities all over America feel that it's an epidemic and we have to do something about this. These statistics show that drunk driving is a crime that must be taken seriously. It's a serious crime, and Assemblyman Jerry Hill is doing just that with AB 1601. After the case against the drunk driver who killed our children ended, our DA urged Peggy and me to get a permanent license revocation in place. So here we are today, finally, and so grateful to have Assemblyman Jerry Hill working on this. Our personal story, as Peggy mentioned, shows that this bill will be strong, a very strong deterrent to drunk drivers. Michael Demetrius, who killed our children, was much more concerned when his sentencing about losing his driver's license, even though it couldn't be done, than actually being sentenced to 6 years, 4 months. We were shocked at his demeanor. He was almost defiant when he was told he would have his driver's license taken away. This confirms my belief that this bill will cause drunk drivers to think twice before they get in a car after they've been drinking.
Okay,
Again, thank you so much, Assemblyman Jerry Hill.
And thank you very much. All right, any other expressions of support?
Briefly, Mr. Chair, members, thank you very much. Sheriff Adam Christensen representing the citizens of Stanislaus County and the California State Sheriff's Association. On behalf of 58 sheriffs, we absolutely support this bill and support the leadership of Assemblymember Hill. Thank you.
Thank you very much, sir. Any other expressions of support?
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association in support, and Dan Felizzato just asked me to express the support of the Los Angeles District Attorney.
Thank you so much. All right, seeing no other expressions of support, any witnesses in opposition? Thank you.
Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice and also on behalf of the California DUI Lawyers Association. We are opposed to this measure. Before I talk about the substance of the bill, I just want to say I understand these are very difficult real-life stories that we hear about DUI, and we've all been touched in different ways and understand how difficult it is for the two witnesses who came before us to talk about their personal experiences. We do appreciate it. Our position is not based on any kind of adverse feeling about them or their families, but certainly is rooted only in looking at the merits of the bill and how we go forward. We've all been touched. My wife almost lost her life to a drunk driver, so I do understand. And I've also have family that have survived alcoholism, so I understand both sides of this issue. But let me tell you what our primary concern is with this bill. There are two provisions, and the author talked really about one of them, but let me focus on the other one. And what that provision will do is treat habitual drivers, ongoing alcoholic folks who keep driving day after day, month after month, despite getting arrested, the same as someone who has 35 years separation between a first offense and a second offense. And that provision is extremely problematic. And by way of example, these are real cases that some of our attorneys have shared with me over the last couple of weeks. Someone who picked up a DUI in 1974, at a time when he was an alcoholic. He achieved sobriety after 5 or 6 years of treatment, went on to live a very prosperous, beneficial life, stayed out of trouble, was at a family function in 2008. His wife was sick, so he drove. He had a glass and a half of wine, got pulled over, and was .10. Was shocked that he was over the limit. Under this bill, he would be treated the same as someone who had the DUI every 2 years, or every 2 months, or every 2 weeks. And that's what's problematic for us. Taking out the 10-year washout, what's been called a washout, is problematic because the original intent was not to wash out priors. And that was part of it. But the other part was to punish those individuals with a higher penalty if they continue to drink and drive, even though they just had a DUI conviction. It was 5 years. Then just 5 years ago, it became 7 years. I'm sorry, it was 7 years, and then 5 years ago it got changed to 10 years. Now we want to remove that 10 years, so it makes it lifetime. So we're now no longer rewarding individuals who achieve sobriety. And it takes away an incentive for folks to achieve sobriety. So that part of the bill is extremely, extremely problematic. The 10-year washout's only been in for 5 years. As far as I know, there haven't been any studies that show that it's not working. And the 10 years is not arbitrary. It's based in a lot of studies. In fact, the DMV's most recent study shows that reoffending, and I'll close in a minute, reoffenses are going down. And in fact, if you have a prior, your first offense is in 1980, within 5 years, 35% of folks will have a second. If your first offense is in 2000, only 17% will have a reoffense within 5 years. And after 10 years, it's only 1% of drivers have another. Let me just close by saying that the DMV already has authority to permanently revoke in narrow cases, and also makes available ways to get treatment so that you can have a reward for achieving sobriety. Those need to stay in place. For those reasons, we're opposed.
All right, thank you. Next witness.
Valerie Small Navarro with the American Civil Liberties Union in opposition. We appreciate what the author is trying to do and his witnesses. I think all of us in our society want to lower the incidence of drunk driving. I think that's a common goal. I would suggest to you, though, and I don't want to duplicate the comments of my colleague here, but I think the bill may be counterproductive, frankly, and if the goal is to get people back on their feet, cleaned up, back into the workforce, and avoid recidivism of any sort, then by taking away somebody's driver's license for life, or or making it virtually in some areas, as we all know, some areas of the state, you cannot get to work without a driver's license. Without a car. You need a car and a driver's license to get to work. So I would suggest to you that in the goal of trying to get people back on their feet and being productive members of society, this bill takes us a few steps backward and really doesn't get us there. In addition to the more technical issues that my colleague raised. So I ask for a no vote and urge you to seriously consider voting no on this bill. Thank you.
All right, thank you. Are there any other witnesses in opposition? All right, seeing none. Comments? Mr. Gilmore.
Thank you, Mr. Chair. First, I would want to say to the author of this bill, I am a co-author, and my deepest sympathy for the author and those that have been supporting this bill. I spent 31 years on the California Highway Patrol. I could write a book on the tragedies that I've personally seen and have lost brother officers as a result of those that are driving under the influence of alcohol. One comment that was made initially, that it is a privilege in this state to drive a vehicle. It's not a right. For those that are opposing the bill, the comment of the individual of driving a vehicle under with a blood alcohol of 0.10. May I tell you from personal experience, the vast majority of the people that I arrested for driving under the influence of alcohol, BAs range from 0.8 to 1.2 to 1.3. Going to the accidents, fatal accidents, and those that are critically injured of driving under the influence of alcohol, the BAs are really quite low in terms of, we're not thinking about a 2.0, what we refer to as a deuce or a 2.5 deuce, but those with lower blood alcohols. And I have personally made arrests for individuals that are 0.8 or 0.9, not a combination of under the influence, but those of just driving under the influence of alcohol of an 0.8 or 0.9, have them open the door of the vehicle and have them actually fall down. So I support this bill. And I would say that those that, I understand the of having to work and to make a living. No one forces you to get behind the vehicle and drive under the influence. There's many ways to circumvent this. This is a choice, a clear choice to drive under the influence of alcohol. And I support the bill. And in fact, without seeming too harsh, Mr. Chair and other members, I would make it, I would do anything, absolutely anything, to get people to not get behind the wheel of a vehicle. It is a weapon, and drive under the influence of alcohol. To see the travesty of families is still have many dreams about many of the accidents that I've seen. So I support you, Mr. Hill, and I would urge an aye vote on this bill.
Thank you, Mr. Gilmore. Any other comments? Mr. Hill, would you like to close?
Thank you, Mr. Chair. Yeah, I would like to respond to some of the comments made by the opposition. Interestingly, 35 years between one offense and another offense. If you understand the bill or understand the current law, that's still a misdemeanor. You have to get 4, and it could be a wobbler, and that 5th one would be a felony. So if you have an offense 35 years apart, a judge is going to take that into consideration, and it's still a misdemeanor as it's being adjudicated. Reoffenses going down, as the statistics that Mr. Ignacio was talking about are showing. I'm sure they are going down. I'm sure less people are getting DUIs because of stricter enforcement, stricter punishment, and it's no longer socially acceptable to drive while you're drinking. That's not something we do as a civilized society any longer, and it needs to be treated that way. The other issue is that you're taking away a license of someone for life. We're taking away a license of someone for life. after certain conditions. It's discretionary with the judge. It's not something that's going to be taken lightly nor done without consideration of a person's behavior, their ability in rehabilitation, the actions that they've taken since the last one, the time involved between DUIs is going to be taken into consideration. And I think probably most important is it was pointed out very clearly that driving is a privilege. It is not a right. It seems to me that the opposition and some are considering that driving is a right. But there is a concern that perhaps we're taking away that right of a drunk driver somehow with this legislation, even though we know it's a privilege. But what about the rights to live and the right to live a healthy life that has been taken away by a drunk driver? I respectfully ask for your aye vote.
Thank you very much, Mr. Mattel. Ms. Skinner?
Apologies, I do have a question.
Sure.
I want to see if I understand this correctly. While the bill authorizes the court to permanently revoke the driving privilege of any person convicted of 3 or more DUIs, eliminating the 10-year washout, are you indicating that the judge still has discretion? In other words, if there's someone with 3 DUIs and it's over a longer period of time, or there's other extenuating circumstances, I want to understand, the bill now does not require the judge to, it purely gives the judge discretion?
Absolutely. Ms. Skinner, the bill, it's clearly defined. It's totally at the discretion of the judge after he has taken into consideration when making that decision a number of things, and have outlined them. The elapsed time since the previous convictions, successful completion of alcohol treatment programs, risk to public safety, how they've lived their life during that period of time, if they're successfully employed, and we all recognize that alcoholism and alcohol is a problem, and it's a problem in someone's life that needs to be corrected. And a judge, as we know, will take that into consideration to make sure to see that they have made those life changes in order to get their life in order and solve those problems. So it's not a mandatory, it's discretionary 100%. Judge.
Mr. Bell? Oh, I'm sorry, another question?
Request to, we seem to have a differing opinion on that in terms of the bill's
Okay,
effect.
briefly, Mr. Hernandez.
The author's correct. On the provision dealing with the permanent license revocation, that's at the discretion of the judge. There's a very narrow list of factors, and we think that list needs to be greater. However, there's not an opportunity to get the license back. Under the other provision where you take out the 10-year, that's not at the discretion of the judge. So if you have 35 years between 2 offenses, it's not at the discretion of the judge to give you the higher penalty, more jail time, longer license suspension, longer treatment program, all of that. That is mandatory. So there are 2 provisions.
All right, thank you. Skinner? Mr. Bell?
I support the bill. I think that the idea, the concept is a good concept. I want to point out one problem that's going to happen. I know it's going to happen. From my work as chair of the Select Committee on Alcohol and Substance Abuse, I know one thing is going to happen this year, and that's that all the Prop 36 programs are going to get totally zeroed out in the budget. That's what's being proposed. There's many of the other probation, drug treatment programs are going to get severely cut back as much as 75%. The in-state prison programs are going to get cut back about 80%. So I think one of the issues is going to be with this bill is how do you achieve a fairness in the situation for people with and without the means to fund their own programs in terms of alcohol and drug treatment in response to legislation. I think we're going to have to deal with that. That's something beyond your bill scope, but it's going to be an issue because you don't want to have a situation where somebody can have an ability or means to finance their own privately funded or insured funded drug alcohol treatment program in response to this versus somebody that just doesn't have any means to take the financial obligation to fund those things has no ability to fund those things. So
Very good point.
I think this is going to be an issue I guess we have to work on in the future if this passes. But I support the bill, and I want to say, I think when judges review these cases, they do take in consideration all the person's life. I think if they had somebody that maybe when they were a young person had a one situation, and then 30 years later they had a situation, I think those kinds of things are taken into consideration at the time in the hearing, especially looking at the person's record in the community and the service or their ability to not have a relapse in terms of alcohol and drug abuse. So and I agree with Assemblyman Gilmore said, driving is a privilege, not a right. It is a privilege, not a right, and there are things we can do to help people like this, but some people are beyond help. They're just not going to respond. And I think when those situations occur, I think there has to be, unfortunately, the right of the laws of California to take away the license permanently, and that's why I support your bill.
Thank you, Mr. Bill.
Thank you. All right, Mr. Hill, very, very compelling arguments from your witnesses and from Mr. Gilmore. It's just with a heavy heart that one hears these stories and can imagine getting on with one's life and the deep, deep, deep personal loss. I still have some pause about this, only in the interest of someone who made a mistake early in life. Obviously, people who have multiple DIs should not be able to drive. Alcoholics do recover. Sometimes they have relapse. It just seems that with the 10 years, there's no ability to appeal. I think your bill is going to get out. I think it's going to be successful on the floor. Today, I will abstain. So if we have a motion, please. Moved. Second. Roll call.
Amiano. Amiano not voting. Hagman. Hagman, aye. Bell. Bell, aye. Gilmore. Gilmore, aye. Hill.
Aye.
Hill, aye. Portantino. Skinner. Skinner not voting. Bill's out.
All right. Thank you all so much.
Thank you.
Mr. Hill, one more.
Yes, thank you, Mr. Chair. Thank you so much. You're very welcome, Mr. Thank you, Mr. Chair and members. This is AB 2068. Under current law, California's expungement process is inconsistent. While the courts have the discretion to dismiss the conviction of someone who served probation as part of his or her sentence, there is no parallel provision for misdemeanor cases where probation was not ordered. That's the only distinction in this bill. AB 2068 equalizes the statutes by adding judicial discretion to the expungements process for people who were not granted probation for a misdemeanor. There is no parallel provision for misdemeanor cases where probation was not ordered. Sentencing without probation has hardly been used since the 1990s in California. As a result, the majority of people that AB 2068 will affect are those who have proven rehabilitation and have stayed out of trouble with the law for extended periods of time, 15 to 40 years, yet are still adversely affected when applying for jobs. An expungement is not a get-out-of-jail pass. A conviction that is expunged remains on the individual's rap sheet and can be used as a prior in future prosecutions. This bill will help people who have proven their rehabilitation to further integrate into society through expanded work and housing opportunities. By increasing access to employment, AB 2068 helps reduce the rate of recidivism and makes our communities safer. Thus, AB 2068 seeks to give these deserving people a chance to continue to fully reintegrate back into society and become productive citizens. With me today are Danielle Jones of the Stanford Community Law Clinic and Rosa Squillicott from the East Bay Community Law Center.
Good morning, Mr. Chair and committee members. My name is Danielle Jones, and I'm an attorney with the Stanford Community Law Clinic, appearing here today on behalf of one of my expungement clients, Ms. Eccles, as well as other clients similarly situated in support of AB 2068. As Assemblyman Hill so correctly pointed out, AB 2068 will correct a statutory inconsistency and provide opportunities for people who have demonstrated rehabilitation to have their misdemeanor record expunged where probation is originally not sentenced. The court still will maintain discretion and power to decide whether or not to grant the expungement relief. Thus, no new judicial mandates are being created through this bill. As an example of how this amendment would affect a real person, I had a client who struggled early in life with substance abuse issues and was convicted on more than one occasion of misdemeanor petty theft in the early 1960s and 70s. In most instances, these misdemeanor convictions occurred very close in time and did not include probation as part of the sentence. This client's last conviction was in 1983. Yet despite compelling evidence of over 25 years of rehabilitation, including demonstrated sobriety and establishment of a successful business over 20 years ago, this client would be unable to get these more than 40-year-old misdemeanor convictions expunged from his record under the current statutory scheme. In summary, AB 2068 corrects for this by, one, equalizing the way misdemeanor convictions are treated for expungement purposes, regardless of whether probation is initially assigned as part of the sentence. A judge can still, in her or his wisdom, decide to exercise his or her discretion to expunge the misdemeanor. And this clarification will actually help judges and advocates working in this realm, as well as clarify the process for expungement petitioners. Finally, this bill requires no new judicial mandates. The legislature is simply unifying California's expungement statutes, so the same discretion that's available to judges under Penal Code Section 1203.4 is paralleled in California Penal Code Section 1203.4a. Thank you for your time and consideration.
Thank you.
Good morning, Mr. Chair and members of the committee. I'm Rosa Squillicote with the Clean Slate Practice of the East Bay Community Law Center. Ms. Jones has just shared with us one client's story. And since the recent economic downturn, our office has seen more clients than ever. Many have lost jobs that they've held for a long time, facing new barriers to employment because of old convictions. The benefits of AB 2068 go beyond these clients' stories, because AB 2068 makes communities stronger and safer. Communities are safer when we prevent crime, and employment decreases recidivism. People with a job are simply less likely to commit a crime than people without a job. And employers want to hire people who need these remedies. At Clean Slate, we have employers recommend clients to us or sometimes call us directly, seeking access to these remedies for their potential hirees. And AB 2068 makes it easier for people who have proven their rehabilitation to get jobs that they are qualified for. Communities are stronger when people are participating in them more fully. Our clients are active in their churches, coach their children's basketball teams, and are positive forces in their communities. And AB 2068 will allow more people to provide for their children and families, to work and pay taxes, and be more active members of their communities. By treating all misdemeanors the same, regardless of the sentence imposed, AB 2068 will play a direct role in reducing recidivism, promoting community economic security, and strengthening families. Thank you for your time.
Thank you so much. Support? All right, seeing none. Any in opposition? Seeing none, that concludes. Mr. Hagman, comment? Bill is moved. With a second?
I do have a question, Mr. Hill. I do appreciate what you're all trying to do here. I do have some concerns based on the parallels of the ones with formal probation, those without. And these are the three that I came up with, and I'm hoping that we can maybe address it as this bill moves along. When you have probation, basically you're kind of guaranteed you're going to be off. I mean, when you get granted this is when you're on formal probation, you're basically staying clean or not getting in trouble for a period of a certain amount of time, 2 or 3 years, depending on the length of probation. I'd like to see that in there, like maybe after 3 years on a misdemeanor or something like that, you go back, the same thing. Even though you're not on probation, have a time period where this may be enacted. That's not necessarily in this language. There's also certain categories, if we have formal probation on felonies, that we exclude. And there's very few that would fit in those type of things on the misdemeanor side, but they are some that I see still maybe you want to bring up to an employer or to a housing project, such as misdemeanor sex offenses. That's not necessarily excluded by this, that you do have in the formal ones. So if you could get some of the same categories of exclusions that you have on the felony side as well as the misdemeanor side, that would make it a lot more palatable. And the last thing I had was, if I could bring my glasses down so we read my notes here. Well, if it's make sure we clarify this, that doesn't deal with felonies. So if we could clarify that point, if I could, have those in the future, I'd be happy to support this too, because I do see the need for people to get back to work, and sometimes when things are way off in the past, I mean, you bring up the examples. Those are the ones we want to address. We want to address that together. The ones that maybe happened, I had 2 or 3 convictions last year, and not just because I'm able to petition out because I misdemeanors. We don't want to address those type of things. We want to make sure there's a certain period of time, but we do want them to be cleaned up in the future too. So I'm just wondering maybe you can work with that and your staff. And
We'll look at those issues that you've raised, Mr. Hagman, and see if they can fit into it. I guess the question is, it's not changing the criteria that's used now for someone who did not have probation. The qualifications are no different, or would be no different.
Change the eligibility.
No change. So,
Yeah.
but we'll look at this and we can chat about it. Thank you, Mr. Hagman.
Thank you. Would
just
you like
clarify
to
the language? That's all. Thank you.
Any other comments? Would you like to close?
Just respectfully ask for an aye vote.
All right, Mr. Hill, thank you. Existing law already allows for some expungement and under certain circumstances in the interest of justice. This expands that slightly so that some of these persons who can clearly show that they are rehabilitated might have a chance at easier reentry. I'm happy to support this bill today and recommend an aye vote. It's moved and seconded, so roll call, please.
Amiano?
Aye.
Amiano, aye. Hagman?
Not voting.
Hagman, not voting. Bell? Bell, aye. Gilmore? Gilmore, not voting. Hill?
Aye.
Hill, aye. Portantino? Portantino, not voting. Skinner? Skinner, aye. It's out.
All right, the bill is out. Congratulations.
Thank you, Mr. Chair. Thank you, members.
Ms. Ma. Item number 3, AB 1800.
Thank you. Good morning, Mr. Chair and members. I am pleased to present AB 1800, a bill sponsored by the California State Sheriff's Association to enhance the penalties on landlord imposters. As the state grapples with record foreclosures, more and more families are struggling to keep a roof over their heads. Since 2008, it is estimated that California has had over 500,000 foreclosures. By 2011, it's expected that California will have over 900,000 foreclosures. With 22% of the country's foreclosures and a housing market saturated with vacant homes, California has become a breeding ground for real estate fraud and rental scams. Over the past year, there have been numerous reports throughout the state where criminals have scammed renters by posing as landlords, posting attractive rental listings on abandoned homes on the internet like Craigslist, and walking away with thousands of dollars in someone's savings. Earlier this year, a young Sacramento woman became a victim when she met an imposter through Craigslist, where she was handed a set of keys in exchange for a large cash deposit and was evicted by the real property owner after she had just moved in. She wasn't able to testify here today because of other obligations, but she would tell you that she has scrambled to find a place to live, and she felt traumatized, betrayed, and lost a lot of faith in people. During these difficult economic times, more and more scammers are coming up with creative ways to scam hardworking, honest, and innocent people. AB 1800 simply enhances the current misdemeanor crime of posing as a landlord to a felony provision in order to deter thieves from walking away with just a slap on the wrist. With me today is Stanislaus County Sheriff Adam Christensen and Christine Minahan from the Weston Center on Law and Poverty.
Yeah, Ms. Ma, isn't it already a felony to walk away with thousands of dollars, anything over 400?
No, it's if you are convicted 5 times of landlord scamming, then it's a felony.
It seems to me the law already covers this, but go ahead.
Christine Minahan, Western Center on Law and Poverty, in support of AB 1800. As Ms. Moss said, we have seen a substantial increase in rent skimming, but it has been with us for quite some time. It was in the last 30 years. We've seen it primarily in lower income neighborhoods and where English is a second language. But what we have had in our local legal services programs now is repeated clients coming in who have been the subject of this kind of a scam. I realize that there is some law already on the books, but we think that this enhances and ensures that the person is going to be more rapidly dealt with in this scam rather than waiting for the 5 incidents. It's particularly troublesome because of the way in which the scam is run, where the tenant goes out to a property that the manager or someone posing as the owner allows them to come in and examine it because they have managed to rekey the locks. They then tell the prospective tenant, you have to come back with the cash within a short period of time. It doesn't allow that tenant who may be wholly unaware that you can go to the county recorder's office and you can ascertain who the lawful owner is. But in these situations, that complex process of going and determining who the real owner is very difficult. Secondly, when they've been told to return with the cash of the first month's rent and the security deposit, they are in a position where they are finding an optimum rental, and most of us would bite. Also want to describe very briefly another iteration of this type of rent skimming that this bill would address, and that is that with former owners will very often...
Be rude, but you've exceeded your 2 minutes. Could you just wrap up?
Wrap up. Former owners go out to the tenants and collect the rent, and they do it knowing that they have no right to that rent. The tenant has no recourse.
Your accommodation. Next witness, please.
Karen Pank on behalf of the California State Sheriff's Association. We're proud sponsors of the bill, and today we have Sheriff Adam Christensen from Stanislaus County here to testify in support.
Thank you. Good morning, Mr. Chair and members. Sheriff Adam Christensen, Stanislaus County. The California State Sheriff's Association is pleased to sponsor AB 1800 to address fraud associated with the mortgage crisis that has affected communities throughout California. We appreciate the leadership of Assembly Members Ma and Hagman on this issue. AB 1800 ensures that scam artists who fraudulently pose as landlords and steal thousands of dollars from innocent people are punished and held accountable appropriately. As the state continues to deal with record foreclosures and families who are struggling to keep their homes, scam artists are using technology like Craigslist and other internet-based sites and internet websites to post deceptive rental and sale listings. Under current law, it's only a misdemeanor to pose as a landlord and take and provide possession of property, steal cash from a renter, and sometimes several $1,000s for deposits of rent, which can also render the victim without a housing alternative. AB 1800 would make it a felony to engage in rent skimming practices. Stanislaus County has seen an increase in the number of these cases in a dozen cases since January of this year. Technology has provided a new medium for the committing of this crime and has warranted this change in law to ensure that an appropriately penalty is applied to rent skimmers and the magnitude of this offense. The State Sheriff's Association is pleased to sponsor AB 1800 to address this issue and help protect our communities from these offenders. While you may believe that we can no longer afford to hold criminals accountable, I believe that our victims can no longer afford not to have our support. And I would ask this morning for your aye vote.
Thank you, sir, very much. Other expressions of support?
Excuse me, Mr. Amiano and members of the committee, Ron Kingston, representing the Apartment Association, California Southern Cities, and the Apartment Association, Orange County. We are in support.
Thank you, sir.
Thank you.
Shanta Pakin with the California Apartment Association in support.
Thank you.
Dawn Kepke with McEwen Associates on behalf of Crime Victims United of California in support.
Thank you. Any other expressions of support? All right. In opposition?
Mr. Chairman and members, Francisco Labaco on behalf of the ACLU. Let me just start with one point. You steal thousands of dollars worth of anything, it's a felony. If I can just read from the analysis, page 3. Also, the defendant may be charged with theft if he or she receives money for rent where the defendant misrepresents his ownership. If the rent received is more than $400, then the defendant may be charged with grand theft, which is also punished alternate felony misdemeanor. I think that's clear. That's the law. The fact is, what this bill is going to try to do is create a new felony where you attempt to and or receive less than $400 worth of money. Given the realities of our fiscal situation, given our realities of our prison situation, given the realities of exposing these folks to 3 strikes, given to the reality that people don't open up the penal code and figure out, well, now I'm not going to do this because penal code 603.7 or whatever it is now been changed to a felony. It's completely unnecessary. I understand a lot of scam artists out there doing this. Scam artists are being appropriately punished. If they're doing and ripping off tenants for lots of money, they can go to state prison now. To the extent that they're ripping them off for less money, we shouldn't have people in state prison who are ripping people off for less than $400, because that is a misdemeanor in all other circumstances. With all due respect, we don't think this is the answer. People can already get deprived of their liberty. If you all want to take a look at dealing with the misdemeanor provisions of this, that's maybe something you can look down. But in terms of creating new felonies, where felonies are not currently the law, we think it's the wrong way to go, and we're opposed.
Is our next speaker?
Thank you. Jim Lindberg on behalf of the Friends Committee on Legislation of California. I concur with the previous witness. We think that for too many years the legislature has indiscriminately increased felonies and ratcheted up penalties. As a result, prison capacity is at 195% or prison population is at 195% of capacity. Prison health care is under federal receivership. We think we just need to be cautious and use prison space very sparingly. Thank you.
Mr. Portantino, I'm sorry.
Yes, thank you, Mr. Chair. I've got a question for the author. I mean, it sounds like this is a serious issue, and I appreciate the law enforcement being here to highlight it. I also can appreciate the comments from the opposition. I just have a question. It seems like this is a serious issue, but I also think there might be some merit to making it a wobbler and giving the DAs the discretion to determine whether it rises to the level of a felony or doesn't. And I'd be more comfortable supporting it if you were willing to make it a wobbler. And I think we address the situation, but also give the DAs discretion. So that would be my question.
Yeah, and I understand the fiscal situation and the situation in our prisons, and I would more than happy to change that and make that amendment in appropriations if it pleases the committee.
Yeah, with that amendment, then I would be inclined to support this.
Okay, so you'll have to, the amendment won't be made here. So the
With the
bill will not be
understanding.
amended till.
Yeah, with the understanding of the author that she would make that amendment in the next committee.
Next committee.
All right. Yeah. Going to ask for any other expressions of opposition? All right, seeing none, Mr. Hagman.
Thank you. And I think it is a felony to have grand theft. It is a lot of different things we can when we take over $400. What the difference with this bill is, and I'm proud to be a joint author on this, is when our investigators, our sheriff, our police are looking at Craigslist and are following up on multiple cases, it doesn't require you actually take the money to be basically prosecuted on this crime. Right now, you could be listed as a landlord of 4 or 5 different places. You met with one victim, and maybe they got a non-sufficient fund check or something like that. The act is still a preventive act that we'd like to see have the ability to go to a felony if it rises that standard. And I agree with the principal author here to give the tools to the district attorney's office, whether it be the wobbler or not, to go through it. But that is the point, is the actual code 602.9 is a misdemeanor right now. With multiple offenses, you can still have a misdemeanor. So be charged 3 or 4 times and caught. We have limited law enforcement resources, and when they do go out and investigate, they need to have some kind of deterrent to stop these people from doing this. So I'll move the bill.
All right, is there a second? It's not amended. There's a commitment to amend. All right. There's any other comments? Ms. Skinner?
While I appreciate the author's expression of amending in appropes, at the moment I'm going to be staying off the bill because while I also understand that there is an increase of this scam, if the scam artists, in fact, rip off any victim by over 400, it can now currently be charged as a felony. So until we have some clarification on, my problem is making this no matter what level, an automatic felony.
Okay. All right, Ms. Ma, I appreciate your commitment to making this a wobbler. It doesn't completely still wash with me, though. Unfortunately, the state of affairs, as you refer to in the Department of Corrections and Rehabilitation, we can't look at individual crimes in a vacuum. There was a time, I suppose, that a bill like this might have been an easy sell. Nonetheless, we don't have the space in prisons to keep creating new felonies. I think the law already says it's a felony. It probably already says that there is some justification for looking at it as a wobbler, although I do appreciate Mr. Portantino's creativity and willing to work with the author. Initially, I had recommended a no on this. I think I will change that to a no recommendation based on your willingness to accept this amendment in appropriations. And if we do have a motion and a second. Is that correct? All right. If we could have a roll call, please.
Amiano not voting. Hagman. Hagman, aye. Bell. Bell not voting. Gilmore. Gilmore, aye. Hill.
Aye.
Hill, aye. Portantino. Portantino, aye. Skinner. Skinner off. It's out.
All right. It's out.
Thank you, members.
Okay. We want to lift the calls.
Anything that's highlighted in blue, please.
Okay. See. All right. I want to lift the call on item 2. Yes.
Make it a wobbler.
Since I was out dealing with my own committee business, I want to add my yes vote to the bill.
To which bill?
Which bill?
The one we just voted on.
The one we just what?
The
The one we just
voted
voted on, Ms. Ma's bill, 1800. All right. Is there any?
I got an explanation from my colleague because I was out dealing with business with my own committee. So.
Yeah. Item number 2. Any lifting the call?
Call absentees.
Absentees are.
Hill.
No.
Hill, no. Skinner.
No.
Item number 2.
Repealing the ammunition law.
Skinner, no.
Ask for reconsideration.
That bill fails.
All right. Ask for reconsideration.
And
Fine.
without objection, we'll grant it reconsideration.
All right. The bill did fail, but we will grant reconsideration.
Without objection.
Without objection. And then on Mr. Miller's 2005-7, the absentees.
Hill.
What was this, 2057?
Item 14.
Oh, I'm 14, I'm sorry. No.
Hill, no. That bill has failed 2-4. And without
All right.
objection,
All right. Did he ask for reconsideration? All right.
Did it pass?
Mr. Hagman, all right, fine, thank you. The bill failed. That concludes the business of the...
Without objection.
Without objection, we'll grant the reconsideration and the... No?
Can we add on?
Yes, and now add on, okay.
Greg, did I vote?
Yeah.
I cast votes for